Thank you very much, everyone. My name's Chris Smith. I'm a barrister at Quadrant Chambers, and for tonight's QBiT talk, I'm going to be answering the question, what is without prejudice privilege? Now, as the name suggests, it's a rule of evidence. It's a rule that says negotiations between parties when there's a genuine dispute, which are part of an attempt to settle that dispute, cannot be admitted in evidence. The justification for the rule is one of policy. The courts want parties to engage in settlement discussions in the full knowledge that anything they say won't come back to haunt them. The privilege applies to all communications that form part of the negotiations, not just documents which constitute an offer. That's quite an important point, because it means you can look at a document and think in isolation, this document isn't WP because it doesn't contain an offer. But when you see it in its context as one link in a chain of negotiations, you realise, it's part of this run of correspondence, it is part of an overall negotiation, and therefore it's subject to the privilege. One other point about the scope of the rule. Once the rule is engaged and you're involved in a WP discussion, the privilege covers everything in the discussion, not just admissions. There's a seminal Court of Appeal case called Procter & Gamble and Unilever. In that case, the court noted that a WP discussion will involve admissions, half admissions, assertions about a party's case, offers, counter-offers, threats, thinking out loud, statements of future plans and possibilities. And the court said all of those are caught by the privilege. You can't say, I'm going to hive off the admissions, those are privilege, and everything else can be disclosed. That was held to be a concept as implausible as the curate's egg. You can't do it. So those are some of the points about the scope of the rule. Now going on to the individual components. Firstly, a dispute. What does this mean? Can there be a dispute before the other party has said its case? If I go up to my counterparty and say, I'm going to do X and Y, is there a dispute at that moment, or does the dispute only arise once my counterparty has said, hang on, you can't do that? Well, the answer is yes, there is a dispute at that point in time. You can see this in several ways. There's something called the opening shot doctrine. That provides that an opening shot in negotiations is subject to the privilege. Now, by definition, because it's an opening shot, the other side hasn't articulated its position yet. They've not said or done anything. Yet, despite that, your opening shot is still privileged. Another question to consider in this context. Is there a dispute if I admit liability and make an offer of alternative performance? Let's say I have a contract to supply you with a case of Chateauneuf-du-Pape. I go down to my local odd bins, they've run out. So I say, I can't do that. What about a case of Tesco's wine? I respond and say, no, but if it's Waitrose wine, we've got a deal. And we start haggling over this. Is there a dispute at this stage? Well, probably not for the purpose of the privilege. Where one party isn't disputing the other party's entitlement under the contract, but is seeking an indulgence, and all the parties are in disagreement about is over the terms of the indulgence, that is not a qualifying dispute for the purposes of the privilege. The third point I would make in this context is that the dispute has to be one related in some way to litigation. It doesn't have to be actual litigation, but it has to be litigation that is perhaps impending. That's the requirement that there's a dispute. Next point to consider, the use of the term without prejudice. Is this determinative? Well, it's clearly important, but the courts have made it very clear that you don't have to use the words. Frequently, parties in dispute won't be lawyers. They're not even aware of what the concept is of the without prejudice privilege, but they can still rely on it if their communications otherwise tick all the boxes. Equally, quite often we find ourselves in a position where you have a foreign lawyer or foreign parties. They've heard the term before, but they're not really sure what it means, and they band it around in their communications willy-nilly. In those circumstances, if they've used it inappropriately, does the fact that they've used the term engage the rule? Answer, no, or at least no, not unless the other requirements of the privilege are established. The Supreme Court held this. The Supreme Court explained this by reference to Charles Dickens and Bleak House. In Bleak House, one of the characters, Mr. Guppy, makes a proposal of marriage to Miss Esther Summerson. Slight spoiler, she turns him down. After she turns him down, Mr. Guppy comments that his proposal of marriage was without prejudice. Now, so far as we know, Mr. Guppy was not a student of English evidential law. The thrust of his comments was that he didn't want to be embarrassed by a later reference to his proposal. The Supreme Court then took that example and, confirming a debate that I think absolutely zero English scholars have ever had, said that Mr. Guppy's communication was not subject to the without prejudice privilege. So, that deals with the use of the term. And the next point I'm going to want to consider is the exceptions to the rule. We're going to go back for these purposes to our old friend, the Unilever case that I mentioned earlier. This is regarded as the classic statement of what the exceptions are, but it's important to note that whilst in that case the Court of Appeal lists 8 exceptions, they're non-exhaustive. Others can come into existence. However, that case is seen as the generally accepted jumping off point if you want to find out what the exceptions are. Now, I'm not going to go through all 8 of them tonight because some of them are pretty obscure, but I will try and identify the most important ones for you. Firstly, the privilege does not apply to a statement made in negotiations which the maker intends the counterparty to rely on, which the counterparty does in fact rely on, giving rise to an estoppel. So you can rely on them for estoppel purposes. Secondly, and simply, where the statement you want to rely on it to show that an agreement has been induced by fraud, undue influence or misrepresentation, you can rely on a WP communication for that purpose. The privilege won't protect you. Thirdly, and this is perhaps the most elusive one, you can also rely on a statement made if you're relying it not to show the truth what was said, but just the fact that the statement was made in the first place. What does that mean? Well, here's an example. Let's say in negotiations, I say that my mate Dave was in Nuneaton on the 12th of February. Okay? Now, in any subsequent proceedings, if there is an issue as to where Dave was on the 12th of February, you can't rely on my statement because you're looking to do so to prove the truth of it, that Dave was where I said he was. But if for whatever reason in some subsequent proceedings there's a debate about whether I ever said that or whether anyone ever said where Dave was on the day, well then you can, under this exception, rely on the statement because you're not looking to prove the truth of it. Now, like I said, it's quite a controversial exception, this, and there are various disputes and debates about its exact scope. To give you an example, there are 2 conflicting Supreme Court cases as to whether or not this exception covers acknowledgements under Section 29 of the Limitation Act. So if you're looking to rely on it, be careful. It's one where the edges are a little bit fuzzy. Fourthly and finally, unambiguous impropriety. This is the good stuff. This is not your common or garden just bad behaviour. This is bribery, perjury, blackmail. A classic example of where a party sought to rely on WP prejudice but wasn't allowed to because of unambiguous propriety is because when they said in the negotiations, well, if this fails, I'm just going to perjure my evidence and actually bribe all the other witnesses, so who cares? Unsurprisingly, the court said you can't do that. However, it has to be conduct of that kind of nature. Anything less than that won't do. So go back to my friend Dave. Let's say after the negotiations, I put in a witness statement that says, actually Dave was in Droitwich on the 12th of February. Can that be relied on and said, well, we can show you the privilege statement to show he's lying now? Well, no, it's not unambiguous impropriety. There could be any number of explanations for it. I could have been mistaken what I said at the earlier discussions. Dave could have been mistaken. He might not know his way around the Midlands. You can't establish unambiguous impropriety. And that's without prejudice privilege.